Have you ever imagined being fined for your own doorbell? Not a new construction project, not a loud party, not even a flashy yard decoration, a doorbell. That is exactly what happened to a homeowner in Michigan who received a letter in the mail that made their stomach drop. The letter did not begin with polite wording. It did not open with, "We need to talk." Instead, in bold writing, it announced, "Third notice, $50 fine assessed." The violation? A Ring doorbell camera. The very same type of device that millions of Americans install to prevent porch theft, to know when packages arrive, to feel safer when someone knocks after dark. In this case, the homeowner had owned and used the doorbell long before the neighbors across the street even lived there. Construction workers had built houses nearby, residents had moved in, and life went on. For months, there was no communication from the homeowners association. Then suddenly, without warning, the first letter the owner ever received was labeled a third notice. The explanation from the HOA was that the camera invaded others' privacy. They instructed the homeowner to point it a different direction away from neighboring units. To justify this, they cited a generic bylaw, no immoral, improper, unlawful, or offensive activity, and nothing that may become an annoyance or nuisance to the community. That kind of catch-all rule is vague enough to cover almost anything, and in this case it was being used against a small camera at a front door. Think about how absurd that is. This was not a hidden camera. It was not angled toward anyone's windows. It was fixed in place, pointing at the same space the human eye sees when opening the front door, the driveway, the street, and the sidewalk. Yet suddenly, the HOA claimed it violated morality and privacy. Imagine being the homeowner, wondering how safety precautions at your own property somehow turned into an improper act. This was not just any property either. The homeowner lived in a detached condo purchased in March 2023. They had followed all the rules, lived peacefully, and even built good relationships with the neighbors on both sides of them. They did not sneak in the camera after the fact. It had been there long before the new family moved in across the street. Instead of reaching out with a conversation, the new residents filed a complaint with the HOA, and the HOA did not knock on the door, send an email, or issue a simple reminder. They issued a fine. Not a first notice, not a second warning, but a third notice as the very first communication. Picture opening that letter. Your heart rate increases, your thoughts spiral, and you wonder if something slipped through the cracks. Was there a meeting you missed? Did earlier notices vanish in the mail? The words "third notice" make you feel guilty for something you never knew about in the first place. And the punishment? $50 for keeping the same doorbell that had existed for years without issue. The reasoning only added insult to injury. The HOA claimed the camera violated privacy. Privacy from what? From the public view of a driveway? From a sidewalk? From a street anyone can walk down at any time? The device could not peer into houses. It could not see through curtains. It showed the same scene visible to every passerby, yet it was branded an invasion of privacy. That word privacy was used as a weapon against common sense. The homeowner did what anyone would do. They left a voicemail asking for an urgent callback. They wanted to understand. How could a doorbell be improper or offensive? A doorbell is where deliveries arrive. It is where friends knock. It is where family members announce themselves. In many modern neighborhoods, it is also where safety begins. Yet here, safety itself had been recast as a nuisance. The more you look at the bylaw cited, the more it exposes the weakness of the case. The rule bans anything immoral, improper, unlawful, or offensive, and anything considered an annoyance or nuisance. But what does that mean in practice? If a doorbell is immoral, what word do we use for actual theft? If it is improper, how do we describe vandalism? If it is offensive, what about genuine harassment? If it is a nuisance, how should we define constant barking or loud music? The language is so broad that it allows nearly anything to be classified as a violation. And in this instance, the target was not an act of disturbance, but a simple, ordinary, protective tool. The emotional weight of this cannot be overstated. For the homeowner, the Ring camera was not about spying on neighbors. It was about security, convenience, and peace of mind. They were not asking to install an obtrusive structure. They were not demanding to alter the neighborhood. They were simply asking, where am I supposed to put my doorbell? When vague morality clauses are stretched to this extent, it no longer feels like the enforcement of community standards. It feels like the exercise of arbitrary power. Perhaps some would argue, just angle it differently. Perhaps a bracket or a slight shift could reduce complaints. But that is not the point. The problem was not a technical adjustment. The problem was the approach. A fine was delivered before a conversation was attempted. The first step was punishment, not dialogue. A neighbor chose a formal complaint over a friendly discussion, and the association backed that complaint with the full weight of authority. This incident illustrates more than just one homeowner's frustration. It highlights a larger issue of how HOAs wield vague rules. Across the country, associations have cracked down on things as minor as the color of a mailbox, the height of a shrub, or the type of holiday decoration on a porch. Now, in Michigan, a doorbell camera has been declared improper. When rules become this subjective, almost anything can be targeted. The critical questions remain. Can an HOA truly force you to point your doorbell away from the street? Who controls the exterior of a detached condo? What do the bylaws really say about cameras when no section specifically mentions them? And what does Michigan law permit when it comes to balancing personal security against association rules? These are the questions this story raises. They are not just questions for one homeowner. They are questions for anyone living under HOA control. Because if a doorbell can be labeled immoral or offensive, then no fixture, no device, no small act of personal safety is safe from becoming the next violation. The issue is not only the camera. The issue is the power to define what counts as an offense, and the way that power can be used without fairness, notice, or reason. This is not just a Michigan story. It is a reminder of how fragile common sense becomes under vague rules, and how quickly ordinary homeowners can be turned into violators without warning. It is a story of HOA injustice. It is a story of a crazy HOA rule. And it is one homeowner standing against the question every viewer must ask themselves, what would I do if my doorbell became the next fine? The story begins in Michigan, where a homeowner purchased a detached condominium in March of 2023. Like many people buying into a community governed by a homeowners association, they understood there would be rules. They knew there would be bylaws and guidelines intended to preserve a certain appearance and sense of order. They accepted that reality when they signed the documents at closing. What they did not expect was that one of the most ordinary and useful features of their home would later become the center of conflict, their doorbell camera. From the very beginning, the camera had been part of the property. Installed before the houses across the street were even built, it had quietly done its job. It recorded deliveries, helped the homeowner feel secure, and was no different from millions of other Ring cameras across the country. Nothing in the association's rules at the time of purchase prohibited it. Nothing in the community standards called for its removal. For months after moving in, life was calm. The camera remained in place, unnoticed, unchallenged, and uncontroversial. The neighborhood itself was like many suburban communities. Detached condominiums lined the streets, with driveways and sidewalks forming the ordinary rhythms of residential life. Neighbors came and went, cars parked in front of homes. Packages arrived on porches. The homeowner had developed friendships with those who lived directly beside them, creating a sense of familiarity and belonging. It was not a place defined by conflict or hostility. Until, of course, the arrival of new residents across the street. When those new neighbors moved in, they never approached the homeowner directly. There was no knock on the door to say, "Hey, can we talk about your camera?" There was no polite mention of discomfort or request for adjustment. Instead, the first action they took was to file a complaint with the homeowners association. From that point forward, the relationship shifted. What had been a quiet and unproblematic part of daily life suddenly became the subject of enforcement. It was not simply the fact of the complaint that shocked the homeowner. It was the way the association handled it. Most people would expect a first notice, perhaps a courtesy reminder or a written message pointing out the concern. That is what fairness looks like. Instead, the first communication the homeowner ever received on the matter was labeled third notice. Along with that phrase came an immediate fine of $50, no explanation about prior letters, no chance to respond before a penalty was applied, just an accusation already elevated to a higher stage of escalation. The language of the letter made the situation feel even more surreal. According to the HOA, the camera invaded others' privacy. The association ordered that the device be repositioned to face away from neighboring units. In support of this directive, they quoted a clause from the bylaws that stated no immoral, improper, unlawful, or offensive activity was allowed, and that no resident could engage in behavior considered an annoyance or nuisance. This was the justification for treating a small, fixed doorbell camera as a punishable offense. At this stage, it is worth understanding what a detached condominium community is. Unlike townhomes or connected condos, detached condominiums are freestanding homes. They often look much like single-family houses, but are governed by a master association that oversees the exterior and common elements. Owners typically hold title to the inside of their homes, but share ownership of the land and certain structures with the association. This gives HOAs broader authority than might exist in a typical subdivision. Exterior fixtures, landscaping, and even the placement of items like cameras can fall under association oversight. Still, authority does not erase the need for clarity. If the rules say cameras are prohibited, that is one matter. If the rules require cameras to be approved before installation, that is another. In this case, however, there was no specific prohibition in the bylaws. There was no section that directly addressed doorbell cameras. Instead, the association leaned on the vague catch-all provision about morality, annoyance, and nuisance. The ambiguity of that language left the homeowner bewildered. How could the act of securing a front door be redefined as improper? How could the angle of a camera facing a public street constitute an immoral act? The homeowner's sense of fairness was shaken. It was not just about the fine itself. It was about the process. The idea that a neighbor could complain without any attempt at personal communication. The reality that the association could escalate directly to a third notice when the homeowner had never seen a first or second. The reliance on a loosely worded clause to justify control over a simple household feature. These factors combined to create the impression that reasonableness had been abandoned in favor of authority for its own sake. Emotionally, the experience was draining. Imagine living in your home, believing you were in compliance with all rules, only to be told abruptly that you were guilty of violating community standards. Imagine the confusion of being accused of privacy invasion when your camera only showed the same view visible to anyone standing in the street. The homeowner began to wonder if the true issue was not the camera itself, but the personal preferences of the new neighbors, amplified by the HOA's eagerness to enforce. At its heart, this case introduction frames the conflict between two competing values. On one side is the homeowner's sense of security and autonomy. The doorbell camera symbolizes the right to know who approaches your home, the ability to monitor deliveries, and the assurance that your property is safe. On the other side is the association's claim of authority, rooted in broad rules about annoyance and propriety. Between them stands the reality of a community in which vague bylaws can be interpreted to cover almost anything, depending on who complains and who enforces. This story also illustrates the subtle but powerful role of new neighbors in shaping HOA dynamics. A single complaint, even one based on subjective feelings, can trigger formal action. Instead of dialogue, the system encourages escalation. Rather than resolving concerns with a simple conversation, the structure of HOA governance often channels disputes into the language of violation notices and fines. What might have been solved in 5 minutes across a driveway instead became a legalistic battle backed by the authority of the board. The case introduction, then, is more than just background. It is a window into how ordinary homeowners find themselves caught in extraordinary disputes. It shows how the structure of a condominium association can amplify small disagreements into formal conflicts. It reveals how vague bylaws leave too much room for interpretation and too little room for common sense. Most importantly, it sets the stage for the deeper questions. How does this conflict escalate? How common is it across the country, and what are the legal and ethical boundaries of HOA power? For this Michigan homeowner, the letter was not just a piece of paper. It was a warning that the balance of fairness in their community might already be tipped. It was evidence that the association could impose penalties without notice and define violations in ways that defied logic. And it was the beginning of a larger conflict that would test the boundaries of both patience and principle. The case was no longer about a camera alone. It was about the meaning of rules, the reach of authority, and the limits of what ordinary homeowners are expected to endure under the control of an HOA. The heart of this conflict lies in how a seemingly simple device, a Ring doorbell camera, became the center of an escalating power struggle between one homeowner and their condominium association. What began as a practical measure for safety and convenience slowly spiraled into a tense standoff involving fines, vague rules, accusations of privacy violations, and the ever-present shadow of HOA overreach. The homeowner had installed the camera, as most people do, to protect their front entry, monitor deliveries, and deter theft. Importantly, the camera had been mounted before the new homes across the street were even built. For nearly 3 years, there were no issues, no warnings, and no neighbors filing complaints. It was an ordinary feature, one that countless Americans have on their doors. Then, without warning, a fine appeared in the mail. Not a first notice, not a friendly reminder, but a third notice, already escalating to a $50 penalty for alleged invasion of privacy. This detail alone baffled the homeowner. How could a third notice exist when no prior notices had ever been received? This immediately raised questions of due process. Associations, whether they are HOAs or COAs, typically must follow specific steps when citing homeowners. A first notice should state the issue, give the homeowner time to correct it, and provide clear instructions. Only if ignored should it progress to a second or third notice, ultimately leading to fines. But in this case, the homeowner was blindsided. It was as though the first 2 steps had been skipped entirely, creating the impression of an organization more interested in punishment than fairness. The accusation itself was equally troubling. The association's letter claimed the doorbell camera violated privacy rules, citing a broad clause from the bylaws. No immoral, improper, unlawful, or offensive activity should be carried on in any unit or upon the common elements, nor shall anything be done which may be or become an annoyance or a nuisance to the co-owners of the condominium. At face value, this language is intentionally vague. It is the kind of blanket clause that can be applied to virtually anything from loud parties to unsightly lawn furniture. Now, it was being stretched to cover a doorbell camera, something that was neither immoral, unlawful, nor inherently offensive. The homeowner pushed back with common sense. Where, they asked, was the doorbell supposed to go if not at the front door? Why was this suddenly a problem only after the construction of new homes across the street? And how exactly could a camera pointing at the front porch qualify as an invasion of privacy when anyone walking by could see the same view with the naked eye? Neighbors and commenters who heard the story were quick to point out the absurdity. Some noted that if privacy was truly the concern, then police surveillance cameras, business security systems, and even neighbors glancing out their windows could all be construed as violations. Others highlighted the inconsistency. If the issue was about aesthetics or uniformity, the AO should have cited the homeowner for an unauthorized exterior modification, not for a supposed moral or privacy violation. This inconsistency revealed what many saw as the real issue, not privacy, but control. As the conflict developed, another complication emerged. The homeowner learned that the HOA wanted the camera pointed in a different direction, away from neighboring units. But this demand ignored the very purpose of a doorbell camera. If angled sideways, the device would no longer capture visitors approaching the door, defeating its security function. Instead of providing safety, it would become an ornamental gadget. This highlighted the tension between security and HOA preferences. While the homeowner valued peace of mind and deterrence against crime, the HOA appeared to prioritize abstract rules that offered no practical benefit to residents. The escalation became even more frustrating because the neighbors, Most directly affected, the ones living beside the homeowner, had no problem with the camera. They were friends and in fact saw the device as beneficial for overall neighborhood safety. The complaints, it turned out, came from new neighbors across the street who had moved in months earlier. Rather than introducing themselves or discussing concerns face to face, these neighbors went straight to the HOA with a formal complaint. This step bypassed the opportunity for neighborly communication and cooperation, feeding the cycle of hostility and fines. This breakdown in community trust is central to the story. Homeowners associations are meant to foster harmony and protect property values. Yet in practice, many associations become battlegrounds where neighbors weaponize rules against each other. A simple conversation could have solved the matter, perhaps by discussing camera angles or agreeing on boundaries. Instead, the involvement of the HOA turned a manageable difference of opinion into an adversarial conflict, with penalties and threats hanging over the homeowner's head. Commenters on the original post also weighed in with legal considerations. Some argued that in states like Michigan, doorbell cameras may not point directly into a neighbor's windows or doors, since those areas carry a reasonable expectation of privacy. Others countered that this interpretation was overly broad if the human eye can see it from a public or common space, then recording it should not constitute a violation. Legal experts often distinguish between outdoor spaces, where privacy is limited, and interior spaces, where privacy is absolute. By this reasoning, the homeowner's camera, aimed at a porch and street view, posed no genuine privacy issue. Another critical layer of conflict lies in ownership. In condominiums, the exterior of the building is often considered a common element owned by the association, even if it exclusively serves one unit. This technicality gives associations greater power to regulate what homeowners can attach to their exterior walls or doors. In this sense, the HOA may argue that the camera is not the homeowner's property to install unilaterally. But again, the problem was not merely the existence of a rule, but the selective and inconsistent way it was applied. If no bylaw explicitly prohibited doorbell cameras, then citing a vague morality clause looked more like a power play than genuine enforcement. The homeowner's frustration reached a boiling point. For them, it was not just about the $50 fine, it was about principle. Why should they pay for something that had been installed legally, openly, and without objection for years? Why should new neighbors dictate how they secured their own front door? And why should an HOA twist broad, moralistic language to penalize ordinary safety measures? These questions resonated with many other homeowners across the country who had faced similar battles over grills, flags, paint colors, or lawn decorations. The conflict illustrates how minor disputes can snowball when HOAs rely on punitive measures rather than collaboration. What could have been resolved with dialogue became a matter of escalating fines, appeals, and potentially even legal consultation. For the homeowner, the camera represented safety, security, and peace of mind. For the HOA, it became a symbol of defiance and control. And in between, the broader community witnessed how rules meant to protect harmony were instead driving division. Ultimately, the main conflict is not truly about a camera at all. It is about competing visions of homeownership. On one side is the individual homeowner who sees their property as a space to secure, personalize, and protect. On the other side is the HOA, which views the property as part of a collective whole, subject to uniformity and the broadest possible interpretation of its rules. When these visions collide, it is often the homeowner who feels the weight of imbalance, as vague clauses and selective enforcement become tools for restricting personal freedoms. This breakdown of conflict reveals the deeper problem. Homeowners often feel they are living not in their own homes, but under the constant scrutiny of neighbors and the associations that empower them. A doorbell camera, meant to bring peace of mind, instead triggered fines, accusations, and a loss of trust. And it is in that contradiction, the clash between safety and control, that the true drama of this story unfolds. What happened to one homeowner over a simple doorbell camera is not an isolated dispute. Across the United States, thousands of residents have experienced eerily similar situations in which homeowners, Associations or condominium boards stretch vague rules, apply them selectively, and penalize ordinary people for ordinary choices. The issue is not just one of rules or enforcement, but of power who holds it, how it is exercised, and how far it can extend into the private lives of individuals. For decades, HOAs have promoted themselves as protectors of community harmony and property values. They argue that by enforcing uniform standards, whether about paint colors, landscaping, or noise, they prevent neighborhoods from falling into decline. But in practice, countless cases reveal a troubling pattern. Vague, open-ended bylaws are used to justify enforcement against homeowners who are not actually harming anyone. These rules become tools of control rather than instruments of fairness. Take, for example, the well-documented case in Texas where a family was fined and threatened with foreclosure over a small flagpole in their yard. The HOA argued that the flagpole was an unauthorized exterior alteration, even though it displayed the American flag, which is federally protected under the Freedom to Display the American Flag Act of 2005. Instead of honoring federal law, the HOA pursued its own interpretation of aesthetics, forcing the family into a costly and exhausting legal battle. In another case in Florida, a homeowner was fined hundreds of dollars per day for planting a vegetable garden in her front yard. The association claimed the garden violated uniform landscaping rules. The homeowner argued that the garden was neat, productive, and sustainable, but the HOA insisted it was unsightly. Eventually, the dispute caught the attention of the state legislature, which passed a law explicitly protecting homeowners' rights to grow food on their own property. This victory illustrates an important truth. HOA abuses often go unchecked until lawmakers intervene. The same dynamics apply to disputes over doorbell cameras. Across the country, homeowners are being cited for security devices that millions of Americans consider standard. Associations sometimes claim these cameras are unauthorized modifications to common property. Others frame them as nuisances or invasions of privacy, just as in the case at hand. The vagueness of these claims makes them difficult to challenge without legal expertise. What one board member considers an annoyance, another might view as a harmless or even beneficial tool for safety. The problem intensifies because many associations operate with limited oversight. While city councils or county boards are accountable to voters, HOA boards are often made up of a handful of volunteers or individuals with personal interests in maintaining control. This lack of accountability creates room for arbitrary enforcement. A homeowner who clashes with a board member can suddenly find themselves the target of repeated violations, while others who commit similar infractions are ignored. It is selective justice, rooted not in fairness but in personal relationships and power dynamics. Legal experts have noted that this lack of transparency is a systemic issue. In many states, homeowners who want to challenge an HOA's decision must go through arbitration or civil court, both of which require significant time, energy, and money. Few individuals have the resources to fight back, and so most end up paying fines they believe are unjust, simply to avoid escalation. Associations, aware of this imbalance, often press forward with confidence, knowing they can outlast or outspend individual homeowners. The widespread nature of these disputes has led to growing public awareness and backlash. Online forums, social media groups, and even dedicated YouTube channels now highlight stories of HOA abuse. These platforms have become safe havens where homeowners share experiences, trade legal advice, and expose bad actors. The Ring camera case is just one among thousands that circulate in these digital spaces, each story reinforcing the larger narrative of unchecked association power. Consider the recurring theme of selective enforcement. One homeowner might be fined for leaving trash cans visible, while another neighbor leaves theirs out for days without consequence. Another might be penalized for holiday decorations deemed excessive, even while nearby homes display similar setups. This inconsistency undermines the supposed goal of HOAs to create fairness and uniformity and instead reveals the arbitrary nature of enforcement. Doorbell cameras are a particularly sharp example of this pattern because they touch on two fundamental values, safety and privacy. Homeowners install cameras to feel secure, deter crime, and protect their families. HOAs claim to protect privacy by restricting these devices. In theory, both sides value important rights. In practice, the broad and vague language of bylaws gives associations the upper hand. What should be a conversation about balancing rights becomes a unilateral decision imposed on the homeowner. Across the country, lawmakers have begun to take notice. In recent years, multiple states have introduced or passed laws aimed at limiting HOA power. Some laws restrict the kinds of fines associations can impose. Others ensure that homeowners cannot be penalized for renewable energy installations, vegetable gardens, or patriotic displays. Still, many gaps remain. Few states have directly addressed the issue of personal security devices like doorbell cameras, leaving homeowners vulnerable to inconsistent or unfair enforcement. What makes these patterns so concerning is not only the individual disputes, but the cumulative effect on trust and community. Instead of fostering a sense of belonging, HOAs often create environments where neighbors spy on one another, report each other, and weaponize rules for personal grievances. In the Ring camera case, the neighbors who filed complaints had alternatives. They could have spoken directly to the homeowner, raised their concerns in good faith, or even worked out a compromise. Instead, they chose the path of escalation through the HOA, setting off a chain of conflict that could have been avoided. The broader pattern across America reveals a paradox. HOAs claim to protect community values, but their methods often erode them. Trust is replaced with suspicion. Safety is compromised in the name of aesthetics or abstract rules. Homeowners are left feeling powerless in spaces they thought they owned. Each new case of overreach, whether about a flag, a garden, or a doorbell camera, reinforces this paradox and pushes more people to question whether HOAs serve communities or control them. This pattern has also exposed a deeper cultural divide. Some Americans see HOAs as necessary guardians of order, keeping neighborhoods clean, consistent, and desirable for buyers. Others see them as petty bureaucracies that stifle individuality and punish harmless behavior. The Ring camera case sits at the center of this debate. To one side, it may represent an unwanted surveillance device. To the other, it is a basic tool of modern safety. The fact that a $50 fine can symbolize such a profound clash of values shows just how fragile the balance between personal freedom and collective governance has become. Ultimately, the story of this one homeowner is part of a much larger picture. Across the United States, residents face fines, threats, and even foreclosure over disputes that could be solved with conversation and common sense. Doorbell cameras, like flagpoles and gardens before them, have become flashpoints in a national conversation about power, fairness, and the meaning of homeownership. The wider pattern is unmistakable. When associations prioritize control over cooperation, ordinary homeowners are the ones who suffer. The conflict over a single doorbell camera in Michigan may seem small on the surface, but the legal and ethical questions it raises are far-reaching. When a homeowners association claims that a camera constitutes an immoral or annoying activity, it is not just enforcing a rule, it is asserting a sweeping authority over what people can do on their own property. Understanding the boundaries of this authority requires examining both the legal framework that governs HOAs and the ethical principles that should guide community life. At the legal level, homeowners associations are typically created through a set of documents known as covenants, conditions and restrictions, or CC&RS. These documents are binding contracts that homeowners agree to when they purchase property within an association. In addition to the CC&RS, associations often have bylaws and rules that outline enforcement procedures, define board powers, and set standards for the community. Courts generally treat these documents as contracts. This means that when a homeowner signs the deed, they are agreeing to be bound by these rules, even if they later find them unfair or excessive. But there are limits. State laws define the boundaries of HOA power, and those laws vary widely. Some states require associations to give homeowners notice and a chance to be heard before imposing fines. Others set caps on the dollar amounts that can be charged. Still, others mandate transparency in board meetings and financial records. In Michigan, where this case originates, the Condominium Act requires associations to act reasonably and prohibits them from imposing rules that are arbitrary or discriminatory. The challenge, however, is that reasonableness is often left open to interpretation. What a board believes to be reasonable can feel wildly unreasonable to the homeowner. The ring camera conflict highlights one of the most pressing legal issues: vagueness. The bylaw invoked by the Michigan HOA prohibited immoral, improper, unlawful, or offensive activity, and anything that may be or become an annoyance or a nuisance. On its face, this language is so broad that it could apply to almost anything. A child playing loudly outside could be labeled an annoyance. A holiday party might be considered offensive. Even hanging laundry on a line could be interpreted as improper. When associations rely on vague catch-all provisions, they effectively grant themselves unchecked discretion to punish whatever they dislike. Courts have sometimes intervened when HOA rules are too vague or enforced inconsistently. In several states, judges have struck down association decisions on the grounds that they lacked clarity or discriminated against specific homeowners. For example, a court in Arizona ruled against an HOA that tried to ban offensive political signs without defining what counted as offensive. Similarly, courts in California have limited associations' ability to enforce aesthetic standards when the rules were ambiguous. These rulings suggest that homeowners do have recourse when associations push their authority too far, but it requires time, money, and legal action resources many people cannot easily afford. The ethical questions are even thornier. At its core, the purpose of an HOA should be to foster community, protect shared resources, and maintain property values in a fair and consistent way. But when an association fines a homeowner for a doorbell camera that causes no measurable harm, the spirit of fairness is lost. Instead of building trust, the board undermines it. Instead of resolving conflict, the board escalates it. This raises the ethical question: should a governing body prioritize strict interpretation of rules, or should it prioritize neighborly cooperation and common sense? There is also the issue of privacy versus security. Ethically, homeowners have a right to feel safe in their homes. Doorbell cameras are widely accepted as tools that deter crime, record package deliveries, and protect families. At the same time, neighbors may worry about being recorded when they walk by. This tension is real, but it should be resolved through dialogue, not unilateral enforcement. Ethically, the association should encourage communication between neighbors before resorting to fines. The fact that the complaining neighbors never approach the homeowner directly speaks volumes about how HOAs can foster division rather than cooperation. Another ethical concern is the question of selective enforcement. If the Michigan HOA allows other homeowners to keep cameras, holiday lights, or exterior fixtures without penalty, but targets one homeowner because of a complaint, it crosses into favoritism and unfairness. Consistency is an ethical cornerstone of governance. Without it, rules lose legitimacy and enforcement becomes indistinguishable from harassment. The stakes in these disputes are higher than they first appear. A $50 fine may sound trivial, but fines often accumulate. In many associations, failure to pay can lead to late fees, interest, and eventually liens on the property. In extreme cases, homeowners have even faced foreclosure over unpaid HOA fines. The law allows associations to treat unpaid fines as debts secured by the property itself. This means that a conflict that begins with a simple disagreement over a camera could, if pushed far enough, end in the loss of a home. Ethically, this raises grave questions about proportionality. Should the enforcement of community standards ever extend to something as severe as taking away someone else's house? The legal framework also raises concerns about due process. Many associations claim to provide hearings where homeowners can present their case. But these hearings are often conducted by the very boards that issued the fines in the first place. This creates an inherent conflict of interest. Unlike courts, which are overseen by neutral judges, HOA boards act as both prosecutor and judge. This undermines the perception of fairness and leaves homeowners feeling powerless. Ethically, any system of governance should ensure impartiality, but many HOAs fall short of this standard. In the broader context, these legal and ethical issues have caught the attention of policymakers. Some lawmakers argue that HOAs function as private governments without adequate checks and balances. They can pass rules, levy fines, and enforce liens powers that mirror those of local governments, yet they often operate in private, with limited transparency or accountability. Ethically, this raises the question of whether private associations should wield such authority without the same democratic safeguards that exist in public institutions. For the Michigan homeowner, the legal and ethical landscape is daunting. Legally, they may be forced to comply unless they challenge the HOA in court. Ethically, they face the reality that their sense of security is being treated as an annoyance. The association has chosen to interpret vague rules in a way that punishes rather than protects. This is not just a dispute over a doorbell camera, it is a dispute over the balance of rights, the purpose of rules, and the very definition of community. In conclusion, the legal and ethical implications of this case are profound. Legally, it highlights the dangers of vague bylaws, selective enforcement, and limited due process. Ethically, it exposes the tension between community standards and personal freedoms, between privacy and security, between authority and fairness. These implications extend far beyond one Michigan neighborhood. They speak to the experiences of millions of homeowners across the United States who wonder whether the associations that govern their neighborhoods are truly serving the community or merely serving themselves.
To better understand the Michigan case of the doorbell camera dispute, it helps to consider how legal experts, community management professionals, and ethicists might interpret the situation. Each perspective sheds light on what is at stake for the homeowner, the HOA, and the broader system of association governance. 1. The legal expert's view. A property attorney looking at this case would immediately focus on the language of the bylaws. The cited provision, prohibiting immoral, improper, unlawful, or offensive activity, and anything deemed an annoyance or nuisance, is what lawyers call a catch-all clause. Such clauses are common, but they are also problematic. They give associations wide discretion to interpret almost any behavior as a violation. Courts, however, are often skeptical of enforcement actions based solely on such vague standards. If challenged, a lawyer would argue that the HOA's interpretation is unreasonable and not supported by a specific, clearly written rule. The attorney would also raise concerns about process. The fact that the first notice the homeowner received was labeled "third notice" undermines the association's credibility. Many state statutes, including Michigan's Condominium Act, require that homeowners be given clear notice of alleged violations and an opportunity to respond before fines are imposed. Skipping directly to a third notice could be seen as a denial of due process. Legally, this opens the HOA to challenge, and the homeowner would have grounds to argue that the fine should be voided. 2. The community management professional's view. An experienced HOA manager would likely see this case as a failure of governance and communication. Best practices in association management emphasize transparency, consistency, and community engagement. Jumping to fines without dialogue undermines trust. A seasoned manager would say that the complaint should have been handled informally first, by encouraging the neighbors to talk directly, or by sending a courtesy notice to the homeowner before escalating. From a management perspective, the real danger here is not the camera itself, but the erosion of goodwill. Once homeowners feel targeted unfairly, they lose faith in the board. This can lead to higher conflict at meetings, reduced compliance with rules, and even difficulty collecting assessments. For a community manager, the priority is to maintain harmony, not to create division. In this case, the board's actions achieved the opposite. 3. The privacy and ethics expert's view. An ethicist or privacy scholar might analyze the deeper values at play. On one side, the homeowner has a legitimate interest in safety. Doorbell cameras deter theft, monitor deliveries, and provide peace of mind. On the other side, neighbors may feel uncomfortable being recorded, even incidentally, when walking by. Both values, safety and privacy, are important. The ethical challenge is balancing them. From this perspective, the HOA's reliance on vague bylaws to declare the camera immoral or offensive fails to address the underlying tension. A better approach would have been to create clear, fair standards about where cameras can be placed and how they should be used. For example, some associations allow cameras on front doors, but prohibit them from being pointed directly into a neighbor's yard. Ethically, this respects both sides. The HOA's choice to fine without dialogue reflects not balance, but authoritarianism. 4. The broader policy analyst's view. Public policy experts often describe HOAs as private governments. They collect dues like taxes, enforce rules like ordinances, and can place liens on property like municipalities. Yet, unlike public governments, they lack robust systems of accountability. Board members are not always trained, elections often have low turnout, and enforcement decisions are rarely subject to independent oversight. From a policy standpoint, the Michigan case exemplifies the risks of giving such broad authority to private bodies without safeguards. A policy analyst might argue that state legislatures need to set clearer boundaries, such as prohibiting associations from fining homeowners for standard security devices unless those devices cause demonstrable harm. Without such reforms, HOAs will continue to use vague bylaws as tools of arbitrary control. 5. The practical takeaway. When combining these perspectives, a clear picture emerges. Legally, the HOA is on shaky ground. Procedurally, it skipped important steps. Ethically, it failed to balance safety and privacy. Practically, it undermined trust in the community. Experts from multiple fields would likely agree that the homeowner has a strong case, not just in law but in principle. The Michigan case also serves as a warning for other homeowners. Experts would advise residents to know their rights under state law, to read their association documents carefully, and to document every communication with the board. They would also encourage homeowners to band together when possible, since collective action often has more weight than individual complaints. Ultimately, the consensus among experts is that this dispute is not just about one camera. It is about the proper scope of HOA power, the importance of due process, and the ethical responsibility of community leaders to act fairly. When associations stray from these principles, they cease to be guardians of community and become sources of conflict.
The story of the Michigan homeowner and the doorbell camera captures more than just a dispute over a piece of technology. It represents the friction between personal rights and collective authority, between common sense and rigid enforcement, between the spirit of community and the reality of power. What began as a simple device on a front door spiraled into a symbol of how far homeowners associations can reach into the private lives of the people they govern. For the homeowner, the conflict was personal. A camera that had been in place since before the homes across the street were even built suddenly became the basis for a fine. A vague bylaw, written in broad and ambiguous terms, was stretched to label a standard security device as immoral and offensive, and an enforcement process that skipped directly to a third notice without prior communication left the homeowner feeling ambushed. The emotional toll of such an experience cannot be overstated. To live under constant suspicion that a neighbor's complaint can trigger penalties, without conversation or fairness, erodes the sense of safety that homeownership should bring. But the story also reflects a broader reality. Across the United States, millions of homeowners live under the authority of associations. Some operate fairly and transparently, but far too many rely on vague rules, selective enforcement, and heavy-handed penalties. Whether it is a flagpole, a vegetable garden, or a doorbell camera, the pattern is the same. Ordinary people are caught between their sense of autonomy and the sweeping powers of private governments. The cumulative effect is a growing distrust of HOAs, a sense that the very organizations meant to protect neighborhoods have instead become sources of division. The legal framework reinforces this tension. Courts often uphold association rules as binding contracts, leaving homeowners with little recourse unless they are willing to invest in costly legal battles. At the same time, vague bylaws like the one cited in Michigan invite abuse by allowing boards to interpret almost anything as a violation. The ethical concerns are equally pressing. When an HOA finds a homeowner without notice, ignores due process, or prioritizes authority over dialogue, it violates the principles of fairness and neighborliness that should define community life. The lessons from this case are clear. First, homeowners must be vigilant. Reading and understanding association documents, keeping records of communication, and knowing state protections are crucial. Second, associations must recognize that their legitimacy depends on fairness. Heavy-handed enforcement may win small battles, but it loses the war for trust. Without trust, communities fracture into suspicion and hostility. Third, lawmakers must take notice. As more disputes emerge, states should adopt clearer laws to protect homeowners from arbitrary enforcement, particularly when it comes to devices as common and beneficial as doorbell cameras. There is also a cultural lesson. Communities thrive not on rules alone, but on relationships. A knock on the door, a conversation over the fence, a willingness to compromise, these are the tools of real community. In Michigan, the neighbors who complained had the chance to engage directly but chose instead to escalate. The HOA had the chance to mediate but chose instead to fine. Each step taken favored confrontation over connection. And that choice is at the heart of why so many HOA stories resonate with people nationwide. The doorbell camera conflict may end with the homeowner paying a fine, appealing the decision, or even taking legal action. But regardless of the outcome, it leaves a lasting mark. It reminds us that home ownership under an HOA is not just about the house we buy, but about the governance we inherit. It reminds us that vague rules can be dangerous when enforced without fairness. And it reminds us that trust, once broken, is not easily repaired. For viewers hearing this story, the call to action is simple. Share your own experiences. Speak out about the injustices you have faced, whether large or small. Comment on how your association has treated you, whether with fairness or with abuse. The more stories are told, the harder it becomes for HOAs to hide behind vague bylaws and unchecked power. By building awareness, homeowners can begin to push for reform, accountability, and most importantly, communities that actually live up to the promise of being places of safety and belonging. In the end, the Michigan case is not just about a camera. It is about what it means to live under rules, what it means to be part of a community, and what it means to balance personal freedom with shared responsibility. It is a reminder that fairness, dialogue, and respect are stronger foundations for neighborhoods than fines, threats, and vague accusations. And it is a reminder that when these principles are ignored, even the smallest conflicts can become symbols of something much larger, a struggle for the very meaning of home.